Well, good afternoon, litigants. This is Cass in Court TV with your girl, Miss Public Info. Court's in session. Who's ready for the first lesson? I am, that's for sure. All right, so we're back off after a big long break, you know. Listen, so I want to talk a little bit about deliberation. So, jury deliberations are a very sensitive time. First, I want to say one thing. I'm sorry about the poor quality of the video playback. It's been a little bit shaky with my internet provider. I am going to get that fixed pretty soon. I think I mentioned, I'm also playing with a few, streaming platforms, streaming software to something that's a little bit more interactive, the like and subscribe sort of thing, instead of you just sort of looking at just me on the screen. So I'm trying my best to work these little kinks out as we go along. So bear with me, stay with me. If you have any suggestions, I'm open to that. I am just starting out in the world of YouTube creator content, so I'm open to suggestions always, always, always open to wisdom. All right, so moving on. Deliberations. So deliberations is a very interesting time for jurors. They've, as I stated, in this particular case specifically, they've been in court for 6 weeks, 6.5 weeks. They've been listening to the case. They've been listening to lawyers argue back and forth on the case. They've been listening to testimony. They've just come out of, presumably come out of a very, lengthy, perhaps in some cases theatrical closing arguments. Closings can be very theatrical. Sometimes you have people, I'm segueing a little bit just so you understand the setup, but like closings are very theatrical. Can be very theatrical. I think I told you yesterday about how closings is the anchor runner. It is the anchor runner of the 4x4 relay team. And closings can involve theatrics. It can involve reenactment of the crime. I think, I've seen people pull out an entire bathtub, I saw that actually on a court TV closing case. But sometimes closings can involve, or even cases can involve the jury actually visiting a crime scene, just so that they can, get a feel for the actual scene in which all of this madness occurred. Sometimes it can include, just actual, like I said, they're going to play that videotape. They're going to play a lot of things. So anyway, back to the deliberations. The jury has just come out of all of that. They've seen a lot of triggering information. They've seen a lot of jarring testimony, heard a lot of jarring testimony. They've listened to witness tearfully, in some cases, tell their stories. They've heard from the prosecution, their passionate arguments from the prosecution. They've heard the passionate arguments from the defense. They've seen the interactions between the defense and the judge and the prosecution. They've heard the objections. They've made these mental notes. They've seen the defendant, how he's been sort of acting and posturing in the courtroom. They've seen how he's been reacting or interacting with his legal team. They saw how Mr. Combs, addressed the judge on yesterday. So they've watched everything. They've been the spectator. They've seen the Combs family come in. They've seen everything, the Kanye West of it all. They've seen all of that. So now they're in deliberations, right? And right now they're not in real time. In real time, what's happening right now, in case you're just coming into the class, is what's happening is the government and the defense, they are currently right now arguing about the closing, about the jury instructions. I'm sorry, about the jury instructions, and we're gonna get to that in a moment. I'm gonna walk you through some of what's been going on, some of what they've been talking about, some of the arguments. But they've been arguing with about some of the jury instructions and what should be there. So that's what's happening now. The jury has been given a break, and so they're presumably at home enjoying their Wednesday off. But that's it. we're going to speak on hypotheticals right now, right? And hypothetical in a future. So in this hypothetical, the jury is in deliberations. They've gone to the jury room, okay? So the first thing, they've gone to the jury room. The second thing that happens, and I have my own notes. Here are my notes. So you see what my notes look like. Here are my notes. So they've gone to the jury room. The second thing that has happened is when they go to the jury room, number two is they review the evidence, okay? Now, in federal cases, I'm told that the foreperson is chosen by the court. That's what I'm told, that the court chooses the foreperson. In a state case, the foreperson is chosen by the jury itself. So in a state case, when they go into the jury room, they will have an opportunity to pick a foreperson. But in this particular case, since I'm told that in Fed cases, the court makes the selection for them, they don't have to take that extra step. So that's why I'm not mentioning that for those of you who might be wondering. So they're reviewing the evidence. Now, what also can happen before they decide to review the evidence is during deliberations, they can make the jury could decide to to take an initial vote just to sort of see where everybody's head is at. And not all juries do this, but some of them do it just to sort of see, especially on complicated cases like this one, where they sort of just, they have a plethora of evidence to sift through, and they have a lot of testimony to sort of go through, to recall, to all of that, right? They may take an initial vote, and after they take that initial vote, let's just say the vote is like, I don't know, I'm just making this up. So let's just say it's split 6 and 6. 6 guilty, 6 not guilty. So then they know they have work to do, because either way they need to get on the same page, right? So then they go into the process of reviewing the evidence. Now, reviewing the evidence could look like, hey, we would like to request to see the video. We need to see the Cassie video again. So presumably there's probably some sort of television inside of there. They probably have it all. They probably have it queued up. You know, they probably have it available, you know, because it's part of the evidence. So I'm sure they have the video and any other, you know, video if they want to see any of the sexually explicit videos. They would have to, you know, just, you know, get that evidence as well. That's when they would start looking at those videos, the voicemails, the text messaging, which I'm sure is, you know, neatly, you know, organized and put together in a binder so they can take a look at it, and recalling all of the testimony. So they have transcripts, obviously, but they also have their own notes too. So they're going to be sifting through their own notes. They're going to be sifting through transcripts. They're going to be looking at photos, the photos of the items that were taken from the search warrant, from Homeland Security investigations when they came through. They're going to be looking at all of the receipts from the hotel where a lot of these freak-offs took place, and they have the receipts from where the rooms were, you know, damaged from the freak-off activity. They're going to be taking a look at a lot of receipts as it relates to payments, because this is part of their consideration of the RICO. So in order to consider evidence as it relates to the RICO, then they have to look at the transference of funds. How was it transferred? Who was doing the transferring? And was it transferred under the legitimacy of Sean Combs's business, his legitimate business? Either it was Bad Boy Global, Sean Combs Enterprises, or whichever, you know, business. He has several businesses and several monikers that he utilizes. And they're going to be looking at key pieces of evidence as it relates to, you know, agents of those folks who helped make things happen. So his personal assistants, his chief of staff, his security. Excuse me for a second, guys. His chief of staff, his security, anyone who has been carrying cash, anyone who, you know, had anything to do with passing money along, paying anybody, they're going to be looking at all of those things. Does this equal a enterprise? And most of this, as it relates to reviewing the evidence, so 2 and 3 are reviewing the evidence and discussing the case. So 2 and 3 go hand in hand. And in the midst of that, they're going to be looking at those jury instructions. Now, I'm told that the jury charge is 100 pages. So I was hoping that it wouldn't even get into the double digits, the high double digits. What was I thinking? But as I told you rightly in the last episode, the jury instructions is going to be longer than Zorro's whip. It's about as long as the Bible. It really is. It's like, this is really, so it's, the jury charge is 100 pages about. So they're going to be looking at those jury instructions, and it's going to take a while to get through it. Now, there are some legal experts who are saying that they think that deliberations is going to probably could probably take, one person said, a couple of days. I would venture to say that it's probably going to take them a few days to get through reviewing the evidence, especially if they're being careful. Now, it all depends on whether or not they're all on the same page. If they're all on the same page, this way or that way, then we have no problem. A jury could come back with a verdict in 30 minutes and the judge will take it. But what cannot happen is a jury that will come back hung in 30 minutes. You cannot come back with a hung jury in 30 minutes, because the judge will send you back to continue to deliberate. And we've seen this with some cases. I'm trying to think about the case that it was where they came back and they were trying to come back with a hung jury after just a few days, and the judge kept telling them to go back again. I can't remember right now, but hopefully I'll remember before the end of this episode. But the reality is that, discussing the case can take quite some time, because you're talking about matching everything up with these carefully crafted jury instructions so that they fit, and then also, making sure that you have gone through all of the evidence, particularly the evidence as it relates to the summation witnesses. And I think I made this assertion in a few episodes ago, where I talked about the summation witnesses being extremely important to the case. That the summation witnesses, these are the agents that went in. These are the paralegals that got on the stand, that sort of culminate all of the evidence, placing all of the receipts together line by line, back to back, and showing you physically this is what this is and how it all sort of fit into this sort of, criminal enterprise. They put it out. I think you've all probably seen these sort of what do they call them, like little diagrams, where you have, the head of the whatever family, and then you have like, the line, and then the sort of 3 people here and 3 people here who are part of the enterprise, and then the underlings under that person. Like, that's literally what the summation testimony did. And so they're going to be looking at those kinds of things, those kinds of diagrams. I wouldn't be surprised if there was a diagram that looks sort of similar to what I just described, that they're going to be looking at to sort of help them make their decision, and then number 4, they reach a verdict. They reach a verdict. They take a vote. I mean, it could take 3 or 4 votes before they reach a verdict that, like, okay, we're ready. They get a verdict, and then they don't immediately just say, hey, to the clerk of the court, we're ready. but they have to fill out the verdict form. So this is the verdict form is what is being read when the verdict is read by, or when the verdict form is given, when the foreperson gives the verdict form to the clerk of the court, and then that's what's being read, the verdict form. So that's exactly, and it just simply, the verdict form is basically the count: RICO count one count RICO, racketeering, guilty, not guilty, so say you guilty, or so say you not guilty. Then count 2 as to, sex trafficking, not guilty, guilty, and so forth and so on. It would be, that's how it would go. That's the verdict form. And then they announce the verdict, as I said. And once the verdict is announced, and I'm sure you guys have seen, our verdicts be announced on television, where they're, told, like, y'all need to be quiet. I don't want any emotion. This is not the time. The judge will say that, it's pretty standard. Like, this isn't the time for you guys to be making whooping noises. I don't want anyone from any side making any noises whatsoever. If you feel like you're going to have a problem, you step outside the courtroom. We want, dignified. They will often ask the defendant to stand upon the reading of the verdict. And then the verdict is read, and then sometimes either one side or the other will ask for the jury to be polled. It's been my, I don't know. Well, but it's been my experience that usually that when it is a guilty, the DA will sometimes ask for the jury to be polled. And that's just a show of proof, just to see, if there was anybody who, didn't agree, They did this in the Karen Reed trial. Her attorneys asked for the jury to be polled. And so they polled the jury. Essentially, what polling the jury is the clerk of the court or the judge, I can't recall now, will ask each juror 1, what was your votes? So say you, and they'll say not guilty, not guilty, not guilty, and they'll go on juror 2, not guilty, and juror 3, not, and they'll continue, to go until they get through, and then there'll be a dismissal. Now, and the dismissal in the case of Sean Combs, if he is convicted, because he's already in the custody of the government, of the Department of Justice, if he is convicted, he will be remanded immediately. Of course, every defendant has a right to request immediate sentencing, but my guess in this particular case, because there are levels in which he can be sentenced, particularly on the prostitution and sex trafficking, separate sex trafficking and prostitution charges. There are sort of, levels from, 15 to whatever, or not. I think 15 is the maximum on the sex trafficking charges. So from like 5 to 15, or on the prostitution charge, I think the minimum is like 1, and you can go up to 10 or something like that. So they probably won't ask for immediate sentencing, but you just never know. But that is something that they can ask for. But because he's already in custody, he would be remanded into the custody of the Department of Justice, and he would go back to the Brooklyn Center of Justice, where he's being held right now. If he were not in custody, he would then be immediately remanded. So they would just, cuff him immediately and take him back there and get him processed, because you're guilty, so you have to go. Sometimes depending on the kind of deal. Now, this happened with, what's the woman's name from the Housewives of Utah or Salt Lake City or whatever her name is? She was found guilty of the fraud charges, and they did not remand her immediately, but what they did was she was allowed to remain on bail as a special request from her attorney, and the judge was lenient and he allowed it, probably because it was a non-violent offense. But uh, he said yes to the request, and she was allowed to stay out on bail until she was required to report to the prison, the federal prison that she's now at to serve out her sentence. So sometimes that happens as well. If you are a person, or your client is somebody that is on bail and they're out on bail, and you make the request that they stay out on bail until it's time for them to serve their sentence. That happens as well, depending on the offense. Now, on this kind of crime, I don't know. It's still, it's SEX trafficking, though it's like non-violent-ish. It's still, a forced labor. SEX trafficking is still a danger to immediate danger to public safety. So I'm not sure they would even consider it on this, but he's in custody anyway, so it doesn't matter. He doesn't have bail, so that's not something they would consider. So okay, so that's deliberations. That's how it goes. Now, just a little trivia for you: the longest jury deliberation on record. Because some people are like, how long can people deliberate? Well, they can deliberate for as long as it takes them. And it depends on the judge. Like, if you're taking a really long time, the judge might be like, listen, guys, this is a hung jury. The judge might call it. You know what I mean? Depending on how long it might be. But the jury can take as long as it needs to take to come to a resolution. Most judges will allow them to work as long as they want. Sometimes, they'll allow juries to work through a weekend if they think they can get a verdict by the end of the weekend to be ready to be read on Monday. Some judges will allow that. It just depends. So you just never know. But the longest jury deliberation on record is 4.5 months. That's 18 weeks. 18 weeks. So in 1992, there was a civil case in Long Beach, California. Of course, it was here in California. Where the case involved a lawsuit filed against city officials alleging violations of the Fair Housing Act. And this case took 11 years to get to trial. 11 years of litigation to get to trial. And then took 4.5 months to come to a resolution. So it's really crazy. And then even after, the deliberations on this, if Sean Combs is convicted of these crimes, you're talking about a series of appeals process. And I think I mentioned, he's going to have a field day on appeals. They're going to get started right away. And it's something that, listen, is he going to be successful if he gets convicted? Is he going to be successful in appealing himself out of custody? I don't know. I don't know the answer to that. Will he be successful in potentially getting a new trial? I don't know the answer to that either. I don't know the answer. I don't think anyone can really answer these questions. But what I will say is, appeals are within his constitutional right to appeal anything that the law allows him to appeal that violates him as a human, as a person, or violates his rights within the confines of receiving a fair and just trial. So, if there's something that happened within the trial, and I keep bringing this up, this potential, juror situation that they felt was just so prejudicial because the man was the only black man on the jury. This could potentially be a, a post-conviction appeal issue for him. And depending on any other issues that came along within the trial as it relates to, some of this stuff that's going on with the jury instructions, you just never know. Any of this could be part of it. So he'll just have to go through the process. Sometimes, the appeals process, and I've, working for the district attorney's office and being in the position that I was in, I saw appeals processes all the time. I mean, our attorneys were in court all the time on appeals process, particularly on the death penalty cases. I was right there with our attorneys as they litigated the appeals on the death penalty cases. A lot of times that included testing new evidence. In this particular case, there's not any DNA situations here, but it does apply as it relates to it could potentially be like, well, there's a new witness, that there's somebody that they didn't talk to that they should have talked to. There's somebody that knew had a key piece of information that they failed to follow up with, or whatever. It's within my client's constitutional right to have that person, or whatever, or this wasn't allowed in court, this wasn't allowed in, or this was thrown out by the trial court, and this should have been allowed in because it would have severely affected the outcome of his trial, of his conviction. It would have affected the outcome of his conviction had they allowed this piece of information in. So it's stuff like that. And when I would, notice some of the appeals that would come through, sometimes I would just be like, well, I wonder if a lot of this is just to keep busy, for some of them, but that's neither here nor there. This is part of, everybody's constitutional right to have a right to appeal to anything, anything that violates our rights as a person, for a fair trial. So, okay, let's take a look at some of what's been happening in the arguments that has been going on. And I'm not going to read through all of it because, I mean, my goodness, who wants to go through all of that? But they've been, again, like I said, the charge doc is 100 pages, which just means the jury instructions. The jury instructions are 100 pages. They apparently had the 100-page jury instructions yesterday, but then now they're making amendments, of course, because on number one of what was amended because of the 3 predicate acts that were removed. So they amended that. So here's something interesting that the judge has said about an hour ago. The Judge Submaranian, he's saying the danger is that the jury thinks that they have to make findings under each racketeering act, Combs act. And then Combs' lawyer says, can you give me a minute? And so then the judge says, page 20, I have one thing to raise. And she says, Mr. Driscoll has reminded me of another suggestion we have. This is case law, Ocasio versus U.S. You have to blame the Supreme Court. Driscoll, another attorney, says you have to prove the conspirators agreed to commit each element. So this goes back to part of the defense's argument yesterday in the Rule 29 argument, where they said that there was no proof that each of the conspirators, so this would be like the assistants, and this would be the anybody that worked for Diddy, the security people, anybody who worked for him, that they would have to have knowledge that they were committing this racketeering act. And so she's giving case law. This Miss Shapiro and Mr. Driscoll are both giving case law and they are saying that they have to prove the conspirators to commit to each commit each element. So this is, them knowingly culpability. He's saying they have to have culpability. So Judge Submarinian says, give me the full sentence, please. And so Mr. Driscoll says on page 19, line 4, after the words actually occurred, you could add that each conspirator must be aware of each substantial racketeering offense. And so then here comes the government saying, we are not required to show that there was an ongoing federal investigation. And from the United States draft that was drafted yesterday, it states that the government is not required to prove that there was an ongoing federal case or investigation. And so the judge says the statute has its elements, using threat to hinder complaint to law enforcement or a judge. And Ms. Shapiro says there has to be a showing the victim intended to approach federal law enforcement, had knowledge of the federal aspect of the offense. So basically, they're saying, the judge is saying the statute has its elements, and that one of the elements is using the threat to hinder, using it to hinder the complaint to law enforcement, like keeping someone from complaining to law enforcement or a judge. And then Ms. Shapiro comes in and says there has to be a showing that the victim intended to approach a federal law enforcement person or had knowledge of the federal aspect of the offense. And I guess they're speaking of as it relates to any of the testimony, I would gather. And again, I'm giving you bits and pieces of it. And here is the government. On the forced labor, the government will be arguing that certain SEX acts can be labor. We will be building off the R. Kelly case. Interesting. The defense argues that the victims are well off, so we need to make this clear to the jury. Now, I'm going to say that again because that is very bombshell. It's just very interesting. We didn't know that that's what they were going to be doing. This is from the United States at the AUSA. This is their attorney, the government attorney, saying, on the forced labor, the government will be arguing that certain SEX acts can be labor. We will be building off the R. Kelly case. The defense argues that the victims are well off, so we need to make this clear to the jury. And then Combs' side says, we object. We are not arguing that sexual acts cannot be labor. Rather than that, the victims here were not particularly vulnerable, that they weren't like second-class citizens, immigrants, or something like that. Like from other countries without immigration status. And so the government comes back and says, in R. Kelly, the Second Circuit said sexual labor falls within the statute. The judge says, I overrule the government's objection. Okay. And she says, the government says, in closing, we will be making this argument. And he said, I think he meant he overruled the Combs' side objection, not the government. He overruled Combs' the defense's objection because they're the ones who objected. So let's repeat. I overruled the defense's objection. And then the government replies, in closing, we will be making this argument. And the judge says, absolutely, sexual services can count as labor under the statute. So we'll end it there. They're still arguing. Tomorrow we'll come back with a full update as to what's happening and when the details in terms of when they're going to get started. I'm going to skim through here to see if they're telling us when they're going to get started tomorrow. I do not know if they are going to tell us when they're going to get started tomorrow. I don't think so. Let's see. So this is interesting before we end. It says, just to move this along, this is the judge, just to move this along because it is getting like, I will add reference to the forced labor statute. On the other, I am including a mens rea requirement in light of the vagueness of challenge. And of course, mens rea is having knowledge of. We think that's insufficient. This is Combs' team saying that we think this is insufficient. The judge says the government is going to argue full-throatedly that there was knowledge, mens rea. And Combs' side says this offense was not in the initial indictment. We are not required to object to the U.S.'s request to charge. And she goes on to say, if the government is now changing what they are going to argue with respect to the drugs, the jurors will notice it. It should be addressed. And the judge says that he agrees. And the government says in Wexler, the sentence about the buyer-seller exception, it should be construed narrowly. Combs' attorney says, that's the context here. And the judge says, I'm going to reserve on this the buyer-seller exception to conspiracy to distribute. So he's reserving probably until the closing. The judge, any objections on the special sentencing factor? No. So he says, so counts 2 and 4, we're almost at the finish line. The court has added that there is no requirement that a SEX act be performed. We object. Combs and Shapiro. The to wit clause of counts 2 and 4, the U.S. used that to trigger the 15-year minimum and to detain Mr. Combs, alleged that these victims engaged in commercial SEX acts, as did the Enterprise letter, so this would be a constructive amendment. And then she goes on. The March 10th Enterprise letter said that they would provide commercial SEX acts. The judge, the government is going to be arguing that commercial SEX acts occurred. What do we do here? And the government said this is blown out of proportion. We're not bound by to wit clauses. So this is, this is a dogfight. So they're basically, fighting about the 15-year minimum on the SEX trafficking account, which is a separate count all on its own. And the defense counsel goes on to say, we're not conceding on the statute. The 15-year minimum only applies if it is triggered. And she's saying that the government triggered that count in order to hold Combs how he is now, and they triggered it. What did she say? She said that they triggered it so that they could hold him, and to trigger the minimum. That they triggered that to trigger the minimum count. They used the to wit clause on the counts 2 and 4 to trigger the minimum. So about 4 minutes ago, Ms. Shapiro says that she says this is very unfair. The judge says, I'm asking you for cases. We need to move on. So he's asking her for case law to address what she's trying to argue. And she says, I will email you cases. And he says, I don't need any further submissions. You'll have the final charge tonight. He's like, I don't want anything else. I don't want to look at anything else. You need to give me the case law now. And she said, and the government says, there's no constructive amendment to include. And she goes on to say, in the International in the Intercontinental, which is the hotel that the Cassie beating took place on camera, there was force and then no completed SEX act. We charged it as SEX trafficking, so they have been on notice. And then Combs's counsel says they maintain in the Intercontinental there was a freak off going on, a SEX act. So they're going to be arguing for some time. I mean, it's 3:24 here in Los Angeles, so it's almost 7 o'clock there. You know, they're in New York. It's really, they're going to be arguing for a while. I don't think that the judge wanted to argue this long. You know, I think he wanted to go on about his business, but here they are. So, I think that they're gonna be. We're just gonna have to wait until the morning just to, you know, find out. I'll probably do a video very early, an episode or very early in the morning to let everybody know when the closings are going to take place. I did hear prematurely earlier today that it was going to be 4 hours of closings for the prosecution and then 4 hours of closings for the defense. So they're gonna, you know, even that up to fit into a full 8-hour day. And then Friday, they were gonna finish up closings because I don't think that they anticipate on actually completing closings tomorrow. So actually the government has already said that they don't think that the jury's going to start deliberating until at earliest Monday. So you have to remember on the closings, you know, there's redirects that happen and there's rebuttals that happen on the closings. They can redirect on the closings. So there's a lot of arguing that goes on. And based on what's happening now on the jury instructions, I expect a fiery, full furnace of fire happening on the closings tomorrow. All right, kids, that's going to be it for today. Because your girl, Miss Public Info, is spent. We spent. It's been a crazy day. I'm going to keep reading the transcript. I'll have some, you know, breakdown for you tomorrow, you know, to give you the play-by-play of what went on. I'll do it early for you guys so you have it. But it started off with a bombshell, so they kind of caught us off by surprise with this. But here we are. We made it. Okay, guys. Well, we're going to adjourn for the evening. This has been Cast in Court TV with Miss Public Info. Thank you for joining us today. We are adjourned. You stay out of trouble. You do the right thing. And we'll see you next time. Thanks so much, guys. Take care.